March 10th, 2026. That date is not a warning. It's not a future deadline. It is right now, and the legal ground beneath every gun owner in America just shifted in ways most people haven't even begun to process. 10 fundamental changes to how gun laws work in this country are not coming. They are here. They are active. They are enforceable. And the vast majority of gun owners, the people these changes were designed to protect, have absolutely no idea any of it happened. That should make you furious because this isn't a small adjustment to some obscure regulation buried in a federal register somewhere. This is the most sweeping transformation of Second Amendment law in decades, and the mainstream media coverage has been so thin, so reluctant, and so ideologically selective that millions of Americans who carry legally, who own firearms, who live in states that have spent years quietly strangling their rights, are still walking around completely blind to the protections they now legally possess. That stops today. If you believe gun owners deserve to know when the law changes in their favor with the same urgency that every restriction ever got wall-to-wall coverage, subscribe right now. Hit the like button and share this with every gun owner you know, because what follows is the information they are not going to get from the evening news. Let's start at the foundation, because without understanding this first change, none of the others make complete sense. For the better part of half a century, courts in this country applied something called rational basis review to most gun control legislation. What that meant in plain English was that the government barely had to justify itself at all. If a state legislature wanted to restrict magazine capacity, ban certain rifle configurations, require permits just to buy a firearm, or mandate waiting periods that served no empirically proven purpose, all they had to do was point to a vague safety rationale, and courts would almost universally let it slide. The burden fell nowhere near the government. It fell on gun owners to prove a law was irrational, which was nearly impossible. Politicians stood in front of cameras talking about common sense and children and safety, and judges nodded along. No hard data required. No evidence that the restriction would actually reduce harm. Just the feeling that something should be done, and a legal framework so permissive it might as well have been an invitation to restrict rights freely. That framework is gone. The Supreme Court's ruling, which carries the full weight of constitutional authority and applies to every level of government from Washington, D.C. to the smallest county in the most aggressive gun control state in the Union, establishes with explicit, unambiguous clarity that all gun laws in America must now survive strict scrutiny. Not rational basis, not intermediate scrutiny. Strict scrutiny, the highest, most demanding constitutional standard in American law. What does that actually require? It requires the government to prove, with real evidence, not rhetoric, not emotional appeals, not political momentum, but actual empirical data, that it has a compelling governmental interest that justifies limiting your constitutional rights. And it doesn't stop there. Even if they can establish that interest, they then have to demonstrate that the law is narrowly tailored to achieve it, meaning it goes no further than absolutely necessary. And they must show that no less restrictive alternative could accomplish the same goal. The entire burden of proof has been reversed. The government has to justify every restriction. Gun owners no longer have to justify their freedom. Think about what that means for the landscape of existing gun laws in America. Thousands of them, across dozens of states, were passed under the old permissive standard, laws restricting magazine capacity, laws banning rifle features that have no functional impact on lethality, laws demanding waiting periods for which there is essentially no credible crime reduction data, laws requiring licenses and permits for lawful purchases that served more as barriers to access than as legitimate safety measures. Every single one of those laws is now legally vulnerable in a way it has never been before. If a state cannot prove with hard, empirical, specific evidence that banning a 15-round magazine meaningfully and measurably reduces violent crime, that law can be struck down. If they cannot demonstrate that a 7-day waiting period is the minimum restriction necessary to achieve whatever compelling interest they are claiming, a court can and should throw it out. The era of gun control legislation coasting through on emotional arguments and political inertia is finished. The accountability era is beginning. Now let's talk about a change that could protect not just your freedom, but your entire financial life. Because there is a category of nightmare that gun owners have faced in this country that most people who don't own firearms don't think about until it's too late. You're in your home. It's the middle of the night. Someone has broken in. You are terrified. Your family is at risk, and you do what the law permits you to do. You defend yourself and your home with your legally owned firearm. The intruder is stopped. You survive. Law enforcement arrives, investigates, and determines that your use of force was justified. No criminal charges are filed. By every measure, the system worked. And then, weeks or months later, you receive legal notice that you are being sued in civil court. Not by the state, not by prosecutors, by the attacker you stopped, or by their family, and suddenly everything you have built over a lifetime, your home, your savings, your retirement, the financial foundation of your family, is on the table because you refuse to become a victim. This is not hypothetical. This is not a lawyer's abstract fear scenario. This has happened to real people across this country, and it has destroyed them. A man in Ohio shot a burglar who was actively breaking into his home at 2 a.m. No charges. Clear self-defense by every law enforcement and prosecutorial standard. But the burglar's family took him to civil court, and a jury awarded them $400,000. $400,000 paid to the family of a man who was in the process of committing a crime against him. A woman in California defended herself from a violent attacker in a public parking lot. She fought back, she survived, and then she faced a civil lawsuit demanding $1.2 million for what the plaintiff's attorney framed as excessive force. These outcomes are obscene. They represent one of the most vicious legal traps ever constructed around the concept of self-defense, because they turned survival into financial suicide. You could do everything right, avoid criminal prosecution, and still lose your home because some attorney convinced a civil jury to second-guess a decision you made in a fraction of a second while fearing for your life. The Supreme Court's ruling closes that trap permanently. It establishes absolute civil immunity for lawful self-defense involving a firearm. If your use of force is legally justified under the criminal standard, no civil lawsuit can proceed against you. The attacker cannot sue you. Their family cannot sue you. No civil attorney can drag you into a courtroom unless they first establish in a criminal proceeding that what you did was unlawful, and if they cannot meet that threshold, the civil case dies before it starts. Your home is not at risk. Your retirement is not at risk. Your children's future is not collateral damage for your decision to survive. For the first time, the legal system is fully protecting the people who protect themselves, and it should not have taken this long. Here is something that has quietly enraged gun owners for years without getting the national attention it deserved. Police officers who violated your Second Amendment rights, who unlawfully seized your legally owned firearm, who arrested you for lawfully carrying when you had every right to do so, who treated your constitutional rights like optional guidelines rather than inviolable protections, were largely shielded from personal consequences by a legal doctrine called qualified immunity. The doctrine held that unless prior court decisions with nearly identical facts had already established that the specific action was unconstitutional, the officer could not be held personally liable. It was a legal catch-22 of breathtaking proportions. Courts couldn't hold officers accountable for violating rights that hadn't already been specifically violated and adjudicated in court, which made it nearly impossible to ever establish the precedent needed to create accountability in the first place. The November ruling breaks that shield as it applies to the Second Amendment. If a police officer violates your clearly established gun rights, they are now personally accountable. Not the department, not the municipality, not some insurance fund that absorbs the cost while the officer faces no consequence. The officer, personally. If they unlawfully confiscate a legally owned firearm, if they detain or arrest someone for carrying lawfully, if they violate Second Amendment protections in a way that any reasonable officer should have understood was unconstitutional, they can be sued directly and they can be required to pay damages out of their own pocket. Consider what already happened in Virginia as a preview of what this ruling makes the new standard. A man was pulled over while carrying legally on a valid concealed carry permit. He followed every protocol, disclosed that he was armed, remained calm, followed every instruction. The officer still seized his firearm without any legal basis for doing so. The man went to court, and the judge didn't just rule in his favor. The court awarded $300,000 in damages charged directly and personally to that officer. Not the department, the officer. That case sent a message. This ruling makes it national law. If you think these protections matter and you want more people to hear about them, take 10 seconds right now and hit the subscribe button. Drop a comment telling me which of these 10 changes hits closest to home for you. This kind of journalism reaches people through your engagement, not through algorithmic charity from platforms that have shown they'd rather bury this than amplify it. Now let's keep going. One of the most dishonest tactics used by gun control states over the past decade has been the creative expansion of what the law calls sensitive places. Courts ruled that people have a constitutional right to carry firearms in public for self-defense. That ruling was clear. States like New York, California, and New Jersey could not simply ban public carry outright anymore. That battle was legally lost. So instead of accepting the ruling, they constructed a workaround so brazen it deserves to be called exactly what it was: a fraud against the constitutional rights of their own residents. They created exhaustive lists of locations where firearms were suddenly prohibited. Parks, libraries, grocery stores, shopping centers, parking lots, public sidewalks, transit stations, entertainment venues. Some states published lists with more than 50 categories of so-called sensitive places. You were technically permitted to carry. You simply could not carry anywhere that a person actually goes in the course of living their life. It was a total ban wearing the costume of a reasonable regulation, and courts for too long allowed it to stand. The Supreme Court's ruling establishes a new, objective standard for what actually qualifies as a sensitive place, and it is built on concrete security infrastructure rather than political preference. A courthouse with controlled entry, metal detectors, and armed security personnel. That is a legitimate sensitive place under the new standard. A government building with real screening and law enforcement presence, that qualifies. A school with proper security infrastructure, that counts. But a public park with a sign stuck in the ground that says no firearms? That does not meet the threshold. A shopping mall that decided unilaterally to prohibit guns with no actual security measures to enforce anything? Not a sensitive place. The standard is now tied to the reality of the location's security architecture, not to whatever a state legislature decided to put on a list to effectively nullify carry rights. States are being required to scale back their sensitive places designations dramatically. Some are reporting reductions of 80% or more because they simply cannot meet the legal standard with the vast majority of places they previously banned. And this connects directly to another critical clarification the ruling makes about private businesses. If you are carrying legally and you walk into a business that prohibits firearms, that business has the right to ask you to leave. Property rights are real, and this ruling does not eliminate them. But here is what changed. They cannot have you arrested simply for entering while armed. The worst outcome of walking into a no-guns establishment while legally carrying is that you get asked to leave, and if you refuse, they can pursue a trespassing complaint. What they cannot do is treat the act of entering as a criminal offense in itself. The criminalization of lawful carry in private spaces without any actual legal basis for prohibition is finished. Your rights do not evaporate the moment you cross a threshold. Let's talk about weaponized bureaucracy, because this is one of the tactics that deserves far more anger than it has ever received. States that wanted to suppress carry rights without eliminating them outright discovered that if you can make the process of obtaining a permit sufficiently miserable, sufficiently slow, and sufficiently uncertain, a substantial percentage of the people who apply will simply give up. This was not accidental. It was strategic, and it was deliberate. You would submit your application, pay your fees, complete your training, pass your background check, do everything the law required, and then the clock would simply stop. 3 months would pass. 6 months. In parts of New York, people waited 18 months or longer for a decision on a constitutionally protected right. No updates, no timeline, no explanation, no accountability. Just your application sitting in a filing cabinet while the state successfully denied you your rights without ever formally denying you your rights. And if you called to ask about the status, you would be told to wait. Always just wait. That deliberate obstruction now carries mandatory legal consequences. Under the new ruling, every state has 60 days from the submission of a completed concealed carry application to approve or deny it. 60 calendar days, not business days, not days when the office gets around to it. If that deadline passes without a decision, the permit is automatically approved by default. They cannot pause the clock with unnecessary requests for additional documentation. If they deny the application, they are required to provide a written explanation with actual legal reasoning, not a form letter. The results have been immediate and dramatic in the states where compliance has already begun. States that previously processed applications over the course of months are approving more applications in 3 weeks than they did in the previous 6 months combined. The delay tactics are finished. If you qualify, you get your permit on time. Now add to this one of the most outrageous categories of overreach that has existed in state gun law. Laws that dictated how you store your firearm inside your own home. Some of these laws were so disconnected from reality that they effectively guaranteed a gun owner would be helpless in an actual emergency. Massachusetts required ammunition to be locked in a container separate from the firearm. California mandated that ammunition be stored in an entirely different room. One county in Illinois required firearms and ammunition to be stored on different floors of the home. Picture what those laws meant at 3 in the morning when glass breaks downstairs. You hear someone moving through your house. You grab your firearm, it's unloaded. You run to another room, fumble in the dark for a key, unlock a second container, retrieve ammunition, and attempt to load your gun while an intruder is somewhere in your home. These laws did not make anyone safer. They made gun owners defenseless at the precise moment that a firearm's purpose is most critical. The ruling establishes clearly and without ambiguity that any storage requirement that prevents immediate access to your firearm in an emergency is unconstitutional. You have the right to store your firearms and ammunition in whatever configuration makes sense for your home, your family, and your actual security situation. If you choose to keep a loaded firearm in a bedside quick-access safe, that is your right. If you have young children and choose to store things differently, that is equally your right. The point is that it is your decision made by you for your household, and the government does not get to override that judgment. For years, gun owners in this country were told correctly that federal law prohibited a national gun registry. The Firearm Owners Protection Act of 1986 explicitly banned the government from creating any centralized system linking specific firearms to specific owners. That protection was written into law because Americans understood clearly what it means when a government knows exactly who owns what weapons. But several states decided that the federal prohibition on their behavior was merely an inconvenience to be engineered around. California built what it called a dealer record of sales system that quietly accumulated detailed records on every handgun purchase going back to 1996. 20 million records connecting names, addresses, and identifying information to specific firearms owned by specific people. Hawaii mandated that every firearm be registered with local police, including the make, model, serial number, and full owner information. These weren't voluntary programs. They were mandatory tracking systems that treated law-abiding gun owners with the same surveillance infrastructure you'd apply to convicted felons, and they operated in direct violation of federal law for years. The Supreme Court's ruling did not just acknowledge these systems, it ordered them destroyed. Every state-run database that tracks individual gun owners or links personal information to specific firearms is a direct violation of federal statute, and these registries must be completely dismantled within 180 days. States are required to notify every affected gun owner in writing that their information has been permanently deleted. Non-compliance means contempt of court charges and daily financial penalties until every record is gone. This is the first genuine court-ordered enforcement of the federal registry prohibition in decades, and it is a victory for both Second Amendment rights and personal privacy that deserves to be understood fully. The ruling also finally brought accountability to one of the most abusive enforcement patterns in recent ATF history. For years, the Bureau of Alcohol, Tobacco, Firearms, and Explosives used minor paperwork errors, a transposed number, an incorrect date written on a form, ink of the wrong color on a transfer document, as justification for revoking federal firearms licenses and destroying businesses. A gun store in Pennsylvania lost its license because the owner wrote the wrong year on a single form. A Texas dealer had his FFL revoked because he used blue ink where black was specified. Every piece of information was correct. Every background check was completed. The business was operating lawfully in every meaningful sense. But the paperwork was imperfect, and that gave the ATF the pretext to eliminate a licensed dealer. This was not diligent enforcement. It was bureaucratic targeting, a method of gun control that avoided democratic accountability by hiding inside administrative procedure. The ruling ends this. The ATF must now prove an actual criminal violation or a documented pattern of serious negligence before revoking any license. Minor errors require a written warning and a reasonable opportunity to correct the problem. The weaponization of administrative procedure against small gun dealers is over. And then there is the change that every traveler with a carry permit has needed for years. Concealed carry reciprocity has historically been a chaotic patchwork of bilateral state agreements that shifted constantly, leaving permit holders to navigate a system so complicated that many simply chose not to carry when traveling rather than risk an inadvertent violation. Your Georgia permit meant nothing in certain neighboring states unless those states happened to have an active agreement with Georgia, which could change without notice. The ruling establishes a national baseline. A valid concealed carry permit issued by your home state is legally recognized in at least 42 other states. No additional paperwork, no extra fees, no separate applications. Your permit is your permit, and it travels with you. Finally, and this one is perhaps the most personally significant for anyone who has ever had to make a life or death decision to defend their home, the ruling fundamentally restructures the burden of proof in self-defense prosecutions. For too long, homeowners who used force to protect themselves from genuine threats still found themselves arrested, charged, and subjected to years of criminal proceedings that cost them tens of thousands of dollars, destroyed their peace of mind, and treated them as suspects for the act of surviving. A man charged with aggravated assault for shooting an armed burglar breaking into his house. A woman jailed for 8 months for shooting her abusive ex-boyfriend who had violated a restraining order and kicked in her door. These people did not fail the law. The law failed them. Under the new standard, if you use a firearm to defend yourself inside your home or on your property, the burden of proof lies entirely with the prosecution. They must prove beyond a reasonable doubt that your actions were not justified self-defense. Unless they can meet that burden, the case does not proceed. You are not required to prove you were right. They are required to prove you were wrong. That is the standard that basic justice always demanded, and it is finally the law. These 10 changes represent the most significant expansion of practical, enforceable Second Amendment protections that this country has seen in a generation. They affect how you own your firearms, how you carry them, how you store them, how you travel with them, and how the law treats you if you are ever forced to use one to save your life. Understanding these protections is not optional if you want to benefit from them. Rights that exist on paper but are unknown to the people they protect are not functioning rights at all. They are words in a document that powerful interests will exploit your ignorance of at every opportunity. If this reporting reached you, if it told you something you didn't know, if it gave you something real to act on, then do 3 things right now. Subscribe to this channel so you get this information as it develops. Hit the like button so the platform's algorithm is forced to show this to people who need it, and share it with every gun owner in your life, because this is the information the mainstream outlets decided wasn't worth a segment. Your rights have expanded. March 10th, 2026 is the starting line. What happens next depends entirely on whether the people these protections were designed to serve actually know they exist. Know your rights. Carry that knowledge with the same seriousness you carry everything else, because the people who want to take those rights away are absolutely counting on your ignorance.